Hello, street law, period 2. Good morning. Wake up. We're going to talk about the law. Woo! Okay. We were assigned Taylor versus the city of Saginaw. To start things out, what happened during the incident in question? In Saginaw, Michigan, they chalked tires. So they put chalk on the tires to see if they moved at all when you were parked, to enforce the parking regulations. Between 2014 and 2017, plaintiff Allison Taylor received 14 chalks and parking tickets for leaving her car downtown past the city ordinances. Defendant Tabitha Hoskins would chalk the tires before issuing a ticket each time. Taylor reported that this was a violation of her fourth Amendment right, the prosecution against unlawful search and seizure. After a failed attempt, the court found that chalking was a search for Fourth Amendment purposes. It is a physical trespass to a constitutionally protected area with intent to get information. Hoskins didn't have a warrant but was entitled for qualified immunity for not having this knowledge beforehand because she was a police officer. The constitutional amendments and rights that were involved in this case. The Fourth Amendment protects individuals from unreasonable searches and seizures by the government. So what was the problem? Taylor filed a complaint against the city and Hoskins, alleging that the tire chalking violated her Fourth Amendment right as stated as the United States versus Jones, which was a different case. To determine whether a Fourth Amendment violation has occurred, we asked two questions. This is a quote from one of the people who was in the case. So to determine whether a Fourth Amendment violation has occurred, we asked two questions. First, whether the alleged government conduct constitutes a search within the meaning of the Fourth Amendment. And second, whether the city was reasonable. Under the community caretaker exception, the city decided that chalking tires was not required to discipline drivers, and that they could find other ways to give parking violations rather than drawing on your tires of your personal property, aka your vehicle. Why did the Supreme Court decide the way they did? Are there related cases that have precedented or helped them come to their decision? The Sixth Circuit found that chalking tires is technically a search of protected area to obtain information. Big uh-oh. It was not to protect the public safety, but to raise revenue through parking enforcement. Boo. The court found that the practice was a suspicionless search and was not based on anything illegal actually occurring. They were trying to catch you in the act rather than they were trying to catch you before the act rather than catching you while you're in your vehicle. Taylor's vehicle was found to be parked lawfully and did not pose any safety or risk to injury to the public. The United States versus Jones was a big referendum because officers put a GPS, big uh-oh, on Jones's vehicle without a warrant to track him and catch him on suspicion of drug possession. It was considered unlawful under the Fourth Amendment by obtaining information by invading his privacy without his knowledge. What were the effects/the results of the case? What are the lasting effects on our rights and the behavior of law enforcement on the government? Our rights equals Taylor versus the city of Saginaw expanded on the Fourth Amendment rights to people by declaring that chalking tires as a search requiring a warrant. It also strengthened the protection against unreasonable searches that were originally seen as a minor infringement. So that's good. Law enforcement. The law enforcement agencies modified their parking enforcement practices to avoid violating rights in the future. They now take careful consideration before taking action without a warrant. This case highlights the importance of probable cause during a legal search. Taylor versus the city of Saginaw went down like this. The city violated the Fourth Amendment by chalking Allison Taylor's car tires to see how long she had been parked and to monitor parking time. This act violates the Fourth Amendment, unlawful search and seizure, as it involves a physical intrusion of her vehicle to obtain information. The court found that the automobile exception and community caretaking exception did not apply in this case. No. And that this was the first case where chalking was actually alleged to violate the Fourth Amendment. Chalking tires is not actually unlawful, but they have here to prove that to prove there was a parking violation to consider it to be valid. So you have to violate the parking laws to have the chalking be valid. So what's the big idea? To put it simply, the city was like, you keep parking for like long periods of time. And they were all like up in her business by rubbing chalk all over her tires. And the city was like, Eureka, that'll do the job. But little did they know they made a big oopsie. And they violated the Fourth Amendment. They marked the car physically to try and make her get a parking ticket. So, Taylor filed a complaint against the city and Officer Tabitha Hoskins, alleging that the tire chalking violated her Fourth Amendment right as stated as the United States versus Jones, a previous case. And, yeah. Thank you for listening. Yay!